Several times a month, I receive the following phone call. It goes something like this. Hey, I've got a claim. It's worth about $2 billion. I can't afford an attorney, but I'll give you 80%, 90% of whatever I recover if you'll just agree to represent me. Now, in the business, the law business, that's called a contingency fee arrangement. As good as it may seem to get 80% of a $2 billion reward, it's usually not a realistic assumption. Most of the time, clients have inflated opinions of what their claims are worth. For instance, what's worth more, 10% of a $1 billion judgment that's uncollectible, or 10% of a $100,000 judgment that's definitely collectible? 10% of nothing is nothing. So lawyers have to look at least three factors when considering whether to enter into a contingency fee agreement. The first factor that a lawyer is going to consider is whether the claim has merit, whether the claim is a good claim, whether it's a claim that's got evidence to support it, whether the client is a reliable witness, or whether there's some crackpot that might go AWOL halfway through the litigation. Is there a statute of limitations issue? Do I have a good claim? Second, even if it's a good claim, how much is the claim worth? If you've got a great claim, but it's only worth $5 or $10,000 or even $50,000, that doesn't give a lawyer a great deal of room to work with. So you need a certain dollar figure that's going to warrant the work and expenses that are put into the case. If, in the best case scenario, the claim is worth only a few $1,000s, it's not going to be a claim that can support a contingency fee arrangement. So a lawyer is going to consider damages from both the worst case scenario and the best case scenario. And if the worst case scenario won't support the fees and costs that the lawyer is going to incur, they're not going to accept the case on a contingency fee basis. Finally, the third factor that a lawyer is going to consider is whether the judgment is collectible. As I said earlier, you can get a $1 billion judgment against a defendant, but if that defendant has no assets, or that defendant's assets are beyond the reach of the court, then the judgment is uncollectible and it's essentially worth nothing. In that event, the contingency fee itself is worth nothing. So a lawyer is going to do their due diligence on all three of those issues: the merit of the claim, the best and worst case damage scenario that the claim presents, and also whether the claim is against a defendant that has assets that can be attached and are collectible. Now, where contingency fees work best is in the area of personal injury. And let me go through the three factors and explain to you why contingency fees work in the area of personal injury. First of all, on the issue of substantive liability, personal injury law has been fairly consistent for decades, if not centuries. When you look at a negligence claim, there are four basic elements that have to be proven in order to obtain a judgment in a negligence case. Duty, you've got to prove that the defendant owed you a duty, that the defendant violated that duty, that the violation of that duty caused you damage, and then you need to prove the amount of your damage. You've got to prove those four issues. And in a negligence case, the duty is generally the duty to exercise reasonable care. Those elements haven't changed for a long, long time. They're very predictable. So that's why personal injury cases work well for the first factor, the merits of the claim. With regard to a claim like negligence, the second issue relating to damages is also relatively easy to assess. Personal injury claims are filed every day throughout the country. Judgments are entered every day on personal injury claims throughout the country. There are databases available where you can literally look up and see what a broken arm is worth, what a broken leg is worth, certainly what someone's life is worth if they live to a certain age and what their remaining life expectancy was. With regard to personal injury claims, you've got a readily accessible damage range that any lawyer can find out within a very short period of time, and in that way calculate, hey, if I'm successful, we're going to end up with damages between X and Y dollars. And then the lawyer can make their own decision on whether that damage range is acceptable to them in terms of the fees and expenses that they will put into the case. Finally, when it comes to personal injury claims, that issue of collectibility also usually isn't a concern. For example, if someone's negligent in driving their car and they injure a pedestrian or another driver, almost everybody, most states require that drivers have car insurance. So if a lawyer sues on that claim and proves liability and is rewarded a large damage figure, their collection concerns are minimal because they're going after a large and, in most cases, a reputable insurance company located right here in the United States. And so there are no issues of collectibility. Now, when you go to my area, a RICO claim, for example, none of these factors usually work out. First of all, you've got the issue of substantive liability. The law in RICO is changing. It's not changing as much as it was 20 years ago, but it's a relatively new cause of action. The statute was passed by Congress in 1970. It changed a great deal in the 80s and 90s and early 2000s. And right now, it's just at a point where the predictability of a RICO claim is stabilizing. So it's exponentially a more complicated case, both factually and legally. And then when you look at the issue of damages are much more difficult to predict, mostly because of proximate cause issues. For example, if a company sues under RICO for lost profits, the issue becomes, well, were these profits lost because you're just a bad business person, or were they lost because the defendants did something wrong to you? Did you not make this money because the weather was bad or the market conditions changed, or did you not make this money because of something the defendants did? In these business cases like this, you have a wide range of possible damage outcomes that are difficult to predict, much more difficult to predict than damages in a personal injury context. And finally, when you get to collectibility in the racketeering area, obviously, if you're going after people who've engaged in criminal activity, they may have certain skills that they have learned over the course of a lifetime in laundering money and placing money beyond the reach of creditors. If you're a true racketeer, you're readily aware of the fact that people are going to be coming after your money once they find out that you're nothing more than a scam artist. So you put that money in places that are very hard to reach. That's why contingency fee cases are a rare animal outside of the context of personal injury. I should mention that in the context of class actions, contingency fees are more common. And of course, a class action is where a claim is brought on behalf of an entire class of people. Many law firms are set up to handle class action litigation on the basis of contingency fee arrangements. They are substantively much more complicated cases than a simple personal injury case. But on the damage side, because you're dealing with a class, if each individual has a relatively small claim, on the aggregate level, all of those individuals add up to a very large number, which makes it worth the lawyer's time and effort to pursue that huge damage award. And finally, when it comes to collectibility, class action attorneys are usually very good at selecting defendants. That's why you see a lot of class actions against banks or against healthcare companies or against pharmaceutical companies or auto manufacturers, other large institutional companies that can't hide through foreign monetary transactions. That's why class actions also tend to work well in the contingency fee area. And finally, when you're seeking contingency fee representation, you have to find a lawyer that will even consider doing cases on a contingency fee basis. Most lawyers get paid on an hourly or flat fee, fixed fee type of arrangement. Make sure you're approaching an attorney who has expressed an interest in taking on contingency fee cases. If a lawyer has expressed no interest in contingency fee representation, it's unlikely that the lawyer is going to consider any type of contingency fee arrangement. In closing, I'm going to say it's always good to focus on the economics of any lawsuit that you want to bring. A lawyer needs to make money off of every case that they handle. As attorneys, we like to have the image of fighting for justice and money being sort of a secondary concern. But in reality, a lawyer is like any businessman. They need to make money by selling their inventory. And a lawyer's inventory is a lawyer's time. A lawyer can't spend time on a case that isn't going to pay off either on an hourly basis or ultimately on a contingency fee basis. Before you approach an attorney about representation, have a plan or a strategy to explain to the attorney why you think the case has economic value. And if your only option is to go for a contingency fee type arrangement, then be realistic in your assumptions and don't overstate your damages, don't overstate the collectibility of the judgment, don't overstate the merits. All you can do is give a realistic and honest opinion to the attorney, but the attorney is going to have to make his or her own decision on whether it makes economic sense within the context of their own practice. That's it for today's law lesson. I'm Jeff Grell.